Hi, I'm Ben Caldwell. Today I'd like to talk to you about the official BBS sample questions for the California MFT Law and Ethics exam. These questions were just released in 2024, and the BBS will provide the correct answers for these questions, but they don't explain why. So I want to talk through them today so that hopefully you'll get a good understanding of why the correct answers are indeed the correct answers. Here's the first one. A 75-year-old client has been in therapy for the past 3 years. After an emotional session, the client offers their expensive diamond bracelet to the therapist and states that they want the therapist to have it. The client states that they do not have any children and they want the bracelet to go to someone who will appreciate it. Which of the following actions should the therapist take to manage the ethical obligation in this case? Now, this is one where you probably have an immediate reaction here that's based on your personal morality, and that immediate reaction is probably going to wind up being correct. But it's still useful to think through, okay, wait, why is that correct? And what are the actual rules that impact the decision making here? Option A, process the client's feelings about the session and accept the gift. Option B, document that objectivity will not be compromised and accept the gift. Option C, explain that it is unethical to accept gifts from clients and decline the gift. Or option D, discuss with the client how the therapeutic relationship could be impacted and decline the gift. Now, as we will get to here, you're not going to accept the gift. This is at the end of a deeply emotional session for the client. It's an expensive gift. It should feel inappropriate to you to accept this gift under these circumstances. But you still want to understand the rules, because really fundamentally what you're being tested on here isn't your morality. It's your knowledge of the underlying legal and ethical rules. If you look at the Camped Code of Ethics, the Camped Code of Ethics does not prohibit MFTs from accepting gifts. What the Camped Code tells you to do is to give thought to the meaning behind the gift and the client's expectations related to the gift. Is it going to impact the clinical relationship in some way? Is it culturally consistent? Will the client expect special treatment as a result of this gift? In this instance, though, again, it's an expensive gift. The client is offering it when they are in this emotionally vulnerable state. They might feel like they owe you something because you have been such a good therapist for them for the past 3 years. Those are reasons that should steer you away from accepting the gift. But it's not unethical to accept gifts. You wouldn't explain that, because that's simply not true. There are situations where it is ethical to accept a gift. So what you would do instead is discuss with the client how the therapeutic relationship could be impacted, and for that reason, decline the gift. Okay, next question. A therapist is discontinuing their private practice. The therapist has referred current clients to other therapists and has given the client's records to those therapists. Presumably there are releases of information involved there. The therapist disposes of all former clients' records that are 7 years old or older by placing them into a dumpster located behind the practice. Which of the following statements describes the therapist's actions in this case? A, the therapist acted legally because they no longer maintain a therapy practice. B, the therapist acted legally because the records were past the legal retention time limit, which, for what it's worth, is 7 years. You are legally obligated to retain records for 7 years after the last professional contact, holding in mind that if any minors are involved in that treatment, then for a minor, you retain their records for 7 years after they turn 18. The clock doesn't start on that 7-year time period until they turn 18. Option C, the therapist acted illegally because they did not arrange for a records custodian. Or option D, the therapist acted illegally because records must be disposed of in a timely manner that protects client confidentiality. Does the law say that you can get rid of records that are more than 7 years old? Yes, it does. But that's not the only thing that happened here. The therapist also placed those records into a dumpster located behind their practice. And the law also says that if you are disposing of records You need to dispose of records in a way that protects client confidentiality. And so if you consider the totality of what's happened in this question, the therapist is not acting legally. They are acting illegally. Option D here is correct. The therapist acted illegally because records must be disposed of in a manner that protects client confidentiality. You will notice even in saying that just now, I left out the piece about records must be disposed of in a timely manner. I did that on purpose, and this is actually not a great sample question because of that piece of the response. There's actually nothing in the law that demands that you dispose of records in a timely manner. The 7-year time limit or time minimum for how long you need to retain records is a minimum, not a maximum. There is no maximum in the law. You actually can maintain records for 20, 30, 40 years if you want to. I don't necessarily think that's a good idea. I'm not a lawyer, of course. But I do think there's a point where retaining records well beyond that 7-year window has diminishing benefits. It's unlikely anybody's going to ask for records that long after treatment. And by maintaining them, you are maintaining some level of risk if there is a breach of your system or a loss of client records, that kind of thing. So I think it's good practice to get rid of records that are more than 7 years old on a regular basis. But there's actually nothing in the law that says you have to do that. Instead, you have that 7-year minimum. Even so, if we look at this question, D is still the most correct answer. It's just that that's a weird clause kind of thrown into option D. But it is still correct that the therapist in this situation acted illegally because they did not protect client confidentiality in how they disposed of those records. All right, next question, prior termination. A 22-year-old client initiates therapy after their previous therapist terminated treatment. The client states that they engaged in a consensual sexual interaction with their previous therapist. The previous therapist then terminated treatment, telling the client that the interaction compromised the therapeutic relationship. Which of the following actions should the current therapist take to manage the legal obligation in this case? I hope if you see a question like this on your exam, this is one of the easiest questions that you will have to face, because it should be simple math in your mind. Sexual relationship with a prior therapist during treatment, I have to give this client that brochure. Therapy never includes sexual behavior. And in fact, if I fail to give the client that brochure, I am engaging in unprofessional conduct. So here we have very clearly the client had a sexual interaction with their previous therapist. And that was during treatment, because it says the previous therapist then terminated treatment. So regardless of anything else, we know that there is a legal obligation here to provide the client with that brochure. Therapy never includes sexual behavior. Let's see whether that happens to show up in our response options. A, contact the former therapist and offer professional consultation. Probably not. B, report the former therapist to the licensing board and file a complaint about unprofessional conduct. That has some appeal to it because, of course, we want to protect other clients from therapists who behave inappropriately with their clients, especially those therapists who seem to be sexually exploiting clients. But that's the client's determination to make. If they want to make a report, if they want to file an unprofessional conduct complaint, that's up to the client, not up to us. C, provide the client with the booklet, Therapy Never Includes Sexual Behavior, and discuss the contents. There it is! I thought that might be in there. And option D, discuss with the client the importance of boundaries and recommend that they press charges against their former therapist. Well, discussing the importance of boundaries is useful clinically. Recommend that they press charges against the former therapist, that's towing the line on like an improper imposition of power. But in any case, none of that in option D, or for that matter in A or B, addresses your legal obligation in this case. Your legal obligation is singular and specific, and it is indeed to provide that client with the booklet, Therapy Never Includes Sexual Behavior. So that one's a pretty easy one. Honestly, in my mind, all of these sample questions are not terribly complex. You will find a mix of easy, medium, and difficult ones on the actual exam, and that's why we have a prep program just for you. Our California LMFT Law and Ethics Exam Prep Program at High Pass Education includes multiple mock exams and a mini mock, more than 200 practice questions in all of them with complete rationales, and also includes our exclusive test-taking skills report that lets you know not just how you're doing in terms of content, but also all of those other test-taking skills that we know impact your likelihood of passing a license exam. So time management, flagging answers, changing answers, what kinds of errors are you making, all that kind of stuff and more. That's in our test-taking skills report. Nobody else has anything like it, and our customers are talking about that as a game changer, which is exactly what we hoped it would be when we built it. Check out that and all the details of our programs at High Pass Education, highpass.com. Once again, I'm Ben Caldwell. I hope this was helpful to you. Talk to you soon.